You have a child you haven't spoken to in 20 years, a brother who's a gambling addict, a sister who you had a falling out with a decade ago. You've written them out of your will. You've made it clear that you don't want them to inherit a dime of your money. But what if I told you that they can still come back and challenge your will? That they can drag your family into a long, expensive, and emotionally draining court battle? It's called a will contest, and it's a weapon that estranged family members can use to hold your estate hostage. Today, we're going to talk about how to protect your estate from the claims of the disgruntled heir. Welcome back. I'm Tua, your estate planning attorney. Family dynamics are complicated, and sometimes relationships break down. But just because you've disinherited someone in your will doesn't mean they won't cause problems for your family after you're gone. Today, we're going to talk about will contests and the steps you can take to make your estate plan as bulletproof as possible. Not just anyone can contest a will. You have to have legal standing. This means you have to be an interested person, which typically is limited to heirs at law. These are the people who would inherit your estate if you died without a will, according to state law: your spouse, children, parents, siblings. Beneficiaries in a prior will. If you had a previous will that named someone as a beneficiary and a new will cuts them out, they have standing to contest the new will. So, even if you've written your estranged son out of your will, he still has standing to contest it because he's an heir at law. To successfully contest a will, you have to prove that it is invalid for one of a few specific legal reasons. 1. Lack of testamentary capacity. You have to prove that the person who made the will was not of sound mind when they signed it. This is a very high bar to clear. 2. Undue influence. You have to prove that the person who made the will was coerced or pressured by someone else into creating the will. 3. Fraud. You have to prove that the person who made the will was deceived into signing it. 4. Improper execution. You have to prove that the will was not signed and witnessed according to the strict requirements of state law. A will contest can be devastating for a family. It's a lawsuit, which means it's expensive, it's time-consuming, and it's public. Your family's private, financial, and personal information will be aired in open court. It can also tear families apart. Siblings are pitted against each other. The emotional toll can be immense. And if the will contest is successful, the court will throw out the will. If there was a prior will, the court might reinstate it. If there was no prior will, the court will distribute the estate according to the laws of intestacy, which means your estranged son might end up inheriting a large chunk of your estate after all. While you can't completely prevent someone from filing a will contest, you can make it much more difficult for them to win. Here's some strategies. Use a no contest clause. This is a provision in your will that says if a beneficiary contests the will and loses, they forfeit their inheritance. This is a powerful deterrent, and it only works if you leave the disgruntled heir something in the will to begin with. Use a revocable living trust. It's generally more difficult to contest a trust than a will. Trusts are not filed with the court, so they are private, and the legal grounds for contesting a trust are often narrower. Build a strong case for your capacity. When you sign your will, you can get a letter from your doctor attesting to your mental capacity. You can even videotape the will signing ceremony to create a record of your state of mind. Communicate your intentions. Consider writing a separate letter to your family explaining why you have made the decisions you have. While this letter is not legally binding, it can be powerful evidence of your intentions. Will contests are a real and growing threat to estate plans. If you have a complex family situation or you're planning to disinherit a close family member, you need to work with an experienced estate planning attorney to create a plan that is airtight as possible. Thanks for watching.